They're dog treats.
Well, it's the
They're for dogs.
presentation.
Yes.
It's the presentation. It looks lovely.
Beautiful. I
Yeah.
love it. Xavier.
Yeah. Oh.
I believe there is an announcement that needs to be made.
Yes. If I could have everyone's attention,
Okay,
please,
everybody,
just for a
everybody.
second. The weekend's here. The weekend is here. We made it. We made it.
Woo-hoo! Little extra sleepy after all the Halloween shenanigans that went on yesterday.
It was a bit much, man.
We had a busy day. We had a whole, we wore costumes, had our Halloween show. It was so much fun.
Yes, it was fun.
But
Definitely.
it's exhausting. And every year I wear a wig, and every year my head itches so bad, and I can't wait to get that wig off.
I'm just going to say this out loud. You pulled that off.
Did I?
You pulled Cruella off.
Thanks,
It was
X.
good.
It was fun. It was a fun costume.
Right.
Xavier, tell them who you were.
I always Frankenstein's monster. We always call him Frankenstein, but it was that old school
Yes.
1980s plastic
Yes.
mask. I figured, let's throw
Yeah.
it back.
It's what all the kids used to wear in the 80s, and
That's
it
right.
looked like a classroom of serial killers.
Exactly.
Those plastic costumes with the little masks.
And if you see the pictures now, they look super creepy, so it works out.
I loved it. Well, I thought it was fantastic.
Thank you.
He was a man of few words yesterday.
That's right.
When he was Frankenstein, I called him Frank. There was a whole lot of grunting that happened. That
right there.
during the show, yeah. So today's a very special day for our producer, Alondra, okay?
Okay.
You know how so many people, your pets are like your kids. You
Right.
love your pets.
Yes.
Well, Alondra is a cat person. She is not a dog person,
Right.
okay? She likes dogs, but cats are her favorite. And today we are celebrating her two cats' birthdays.
Oh, nice.
Winona and Saturn.
Winona, I love that name.
Winona Judd or Winona Ryder? Okay, either. Winona Maria
That's great.
and Saturn.
Oh, she's got a middle name too.
Who
Okay.
was the one with those extra long whiskers? Was that Winona? That was Winona. Okay. Well, happy birthday to your little kitty cat.
Those are great names, by the way.
Yeah, hopefully they're watching right now.
That's awesome.
Alondra said that Winona Maria is for her mom's middle name.
Hey,
Does
do
your
you
mom
think?
your mom knows that and she's cool? She hates it. Her mom, hates it. Yes. Well,
That's so funny.
she did it out of love.
Right.
Is that right?
Yes.
Just real general
Just
concepts?
general.
Okay. About like Fourth Amendment searches, Sixth Amendment, right to counsel, things like that?
Things like that.
Okay. About how many cases have you handled while in the homicide unit? More or less.
I don't know. I don't know. I want to say like 10.
And that's been through the whole 4 years, you said?
Yes.
Okay. And a few of those have even gone to trial, right?
Yes.
Or is it the 10 that have gone to trial?
No.
Okay. About
I've
how
only
many-
done 2.
Perfect, thank you. And throughout your work with the prosecutor's office, you're known for being pretty thorough, isn't that right?
Yes.
You're known for being pretty detailed?
Yes.
Okay. And as part of your work at the DA's office, you received training on the DA's protocols, like the procedures on how to handle a criminal case, right?
Yes.
Okay. You've been trained on like their computer systems, right?
Yes. Kind of.
Okay, well explain, what do you mean kind of?
In the beginning, no. I learned by myself. And then when they moved me to the unit, then they trained me.
Okay. And as part of your training, you also learned about the DA portal, is that right?
Yes.
And you learned about GTL, is that right?
Not until I went to the unit.
Okay. And how long have you been in the unit?
I think they moved me to the unit in the end of April, early May.
Of 2024?
I don't know. When did she start? When did Mr. Rosales start? 2020, I think. She started in 2020.
Okay.
So I got there in April, May, was that?
Of 2020?
Mm-hmm.
Mr. Lentz, just a little bit louder for me, please.
Okay.
Thank you.
So as part of your role now, it includes reviewing a lot of the critical evidence, is that right?
Yes.
And when you review evidence, you have to make sure that it's handled correctly. Is that fair?
Yes.
And isn't it the case that actually your office trusts you with the really sensitive material?
Yes.
And part of that means you can't go talking to other people about it. You've got to be very careful on what you do with that.
Yes.
Is that right? And from those 10 cases you talked about, management of evidence was actually pretty crucial in all of those, right?
Yes.
As part of your job, have you been trained on how to review evidence? Like what to look for?
No, because, I mean, that's paralegal, that's what you do. I mean, they didn't train you.
Do they train you on how to summarize, how to take notes on what you review?
No.
Yeah. And so what's your typical practice when, let's say you open up interrogation video, for example, and as you have it open, do you take handwritten notes, do you type out notes, or how do you normally record what you do?
It just depends on whatever I'm going to be looking for. If I'm looking for something specific, if I listen and I hear it, then I'll write it down. But if it's not, then I'm not going to write it down.
And do you track what evidence you open to review?
Yeah.
And do you track that on a paper log or on a computer system?
Well, it's because I don't know what you're trying to ask me. Like, depends on what it is, or like, if I have a task that I have to do, and then I write it down like that, or I don't know what you're asking me.
Okay. Well, let me be a little bit more specific then. Let's limit it to jail calls.
Okay.
When, I assume the way the procedure goes is that one of the attorneys will tell you, this is what we want you to look at, this is what we're looking for? Is
Right.
that fair?
Right.
Okay. And then, so when you're reviewing that jail call, where do you keep your notes on what happened or what was said?
On a handwritten, a notepad. Like, for example, in the jail calls, they'll tell me, listen to the jail calls and make sure that they see if there's any criminal activity, if they don't talk about drugs, weapons, anything like that. And if you do, then write it down. So that's what it is.
So whenever you access a jail call, it's because an attorney gave you a task to look at that specific jail call. Is that fair?
Yes.
You don't just go rummaging through
No.
everything? Yeah, that would be ridiculous. Okay. So when you write it down on your notes, where do you keep that notepad or notebook? Where do you typically?
If I write notes on the call, I'll write it down on a notepad
And where does that notepad end up?
with a box.
The box meaning the case file?
Yeah, whatever the box, like we have a box of a case, we'll put it in the box.
Okay. Your handwritten notes of the jail calls, do you ever scan them in and put them into the DA portal?
No.
Okay. The physical copy just stays in the physical box, is that
Yes.
fair? Okay. And ma'am, did you watch the live stream of yesterday's hearing?
No.
Okay.
They told me not to.
I'm sorry?
They told me not to.
Okay, perfect. So when you look at inmate communications, be it a letter, a jail, your office has very specific policies in place about reviewing it. Is that fair?
Yes.
Okay. And when you review the jail calls, do you kind of provide a summary of what you read or what you found in the email to the prosecutor?
Only if I get what I'm trying to, if I listen to what I heard. For example, oh, this person was talking about drugs. Okay, this guy on this day wrote. But if he didn't, I don't.
Okay. So would you respond to them, telling them, I didn't find anything you were asking me to look for in this case?
No, I'll write it down and I'll put it on a little notepad.
Okay, perfect. And that notepad goes in the physical box?
Yes.
Okay. Now, you're very familiar with the GTL system, is that right?
Now I do. Before I wasn't.
Okay. When you say now and before, what time period are you talking about, more or less?
In the beginning, I didn't.
Okay, when you first started?
Right.
But when you came into the unit, that's when you became more familiar with GTL, is that fair?
After a couple of cases, then I started familiarizing with it.
Okay, that's about late 2020, would you say that you became familiar with it?
Yes, about.
So the way I understand it, and correct me if I'm wrong, is that with the GTL system, you can access and listen to the calls on the website, is that right?
Yes,
Okay. And to access that website, you have to log in, is that right?
yes,
And you have to put in a password, is that right?
yes.
You have to actually search for the inmate,
Yes, 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 yes.
and then you can even filter it by the date that you want to listen to, right?
No, not back then, no.
Okay, but now you can, right?
Yes,
Okay. And so, when you log in, you have your own credentials, is that right?
yes,
That's particular just to you, and everyone else has their own credentials, is that right?
right,
And you don't share your credentials with other people, right?
right.
Okay. Okay, so we have the website, but then you can also take calls and download them onto your computer, is that right?
I don't know. I didn't, the old system, I really wasn't familiar with it. And honestly, I'm not very computer savvy, so I don't know if you could save it. I don't know.
Okay. So when you would listen to them, I mean, in your whole experience with the prosecutor's office, would you only listen to them on the website, or would you also listen to them on the portal, the CD, a DVD?
No, only on GTO.
Only on GTL, okay. Have you ever downloaded any of the jail phone calls to your computer?
No,
Now, you're aware that when you listen to calls on the GTL website, it tracks who listened to the call, is that right?
now I do. I didn't know before.
Okay. And by saying now you do, it's because of the calls that came out in this case, is that right?
Right,
Okay. And you know that when you open a call at GTL, it might be a call between an inmate and his lawyer, right?
no, I didn't know that.
You didn't know that before?
No,
Okay, so the only time that you were aware that an inmate's talking to his lawyer was after the incident in this case. Is that fair?
yes,
Okay, so before that happened, whenever you listen to a phone call, you never listened to a call with the lawyer and his inmate before that?
no,
Okay, it was always just an inmate and who knows who else, right?
right,
And the reason why is because you know that attorney-client phone calls are privileged, right?
Right.
And you know they're confidential, right?
Right.
And you know you're not supposed to listen to them,
right.
Okay. So if that were to happen, as soon as you find out that an inmate's talking to his lawyer, you stop listening to that call, right?
Yes, and that's what I did.
Okay. So I guess we kind of have two time periods, before the incident and after the incident. So before the incident, the DA's office did not have any training, procedures, protocols for identifying privileged calls before you listen to it, right? You'd actually have to listen to it,
Right.
okay? And is that the case now? Are there protocols in place to prevent you from being able to listen to an attorney-client phone call before you actually open it?
I guess so, because I haven't come across another one.
Okay, but you haven't been trained on any of those procedures, right?
With the new system, yes.
You have been trained?
With the new system, yes.
Okay, and that new system, more or less, when did that new system start?
I want to say last year, at the end, toward the middle of last year.
The middle of 2023?
Mm-hmm.
Okay.
Ma'am, do me a favor, my court reporter can't take down nods or uh-huh. I need you to say yes when you're thinking of saying that. I'll try to help you with that.
Okay.
Thank you.
May I approach, Your Honor?
Yes, you may.
Okay, ma'am, I'm showing you what's marked as Defendant Exhibit 6, and I'm going to go ahead and leave that copy with you right there. Have you seen this before, ma'am?
No.
Okay. But you're aware generally of the information provided there as to when you listen to calls and what you listen to, right?
Yes.
Okay. So I want to talk to you about 4 specific calls that are listed in Defendant's Exhibit 6.
Sorry, if I might just have just a brief glance at Defense Exhibit 6.
We've seen it, Your
Oh,
Honor.
you see it?
It's,
Thank you. Sorry. hold on.
we have no objection to its admission. I'm assuming he's on.
All right, we offer and move to admit Defendant's Exhibit 6, Judge.
Defense Exhibit 6 is admitted into evidence for the purpose of this hearing only.
Okay. And so as we go through each one of these, Mr. Hernandez, first I want to start kind of laying it by asking you, If you agree with what the state says in its response, that the state only received 4 phone calls between Crucius and his attorneys, only one staff member in the district attorney's office has listened to those calls. That staff member was you, is that right?
Right,
Okay. And you listened to those four phone calls, right?
right.
Okay. And so the response goes on to say, that there was a DVD-R of those 4 phone calls, right?
Yes,
Did you see that DVD-R?
no,
Okay. Did you ever access the calls from that DVD-R?
did I look at them in GTL? Yes,
Okay, but you did not ever look at them through the DVD-R?
no,
Okay. And you're not aware if anyone else looked at them on that DVD-R, right?
I don't know.
You don't know? Okay, fair enough. Okay, so what I want you to do, if you look at that first one, you see that it says it was played on July 13th, 2022 at 10:15 a.m. Is that correct, ma'am?
Yes,
Okay. And that was a phone call to a phone number 915-544-7600. Is that right?
yes,
And actually, let's make it easy. All those calls are to that same phone number, the 915-544-7600. Is that right?
yes,
Okay. Then, on that same day, looks like about 6 minutes later, you listened to another phone call that was about 940 seconds long. Is that right?
yes,
And then on July 29th, 2022, at 4:06 p.m., you listened to a third phone call. Is that right?
yes,
Then on August 7th, 2022, you listened to a fourth phone call. That's 169 seconds long. Is that right?
yes,
Then on August 7th, 2022, so it looks like a few minutes later, you listened to a fifth phone call that was 561 seconds long. Is that right?
yes, yes,
Okay. And then that same day, looks like 3 hours later at 8:50 p.m. on August 7th, 2022, you listened to a sixth phone call. Is that right?
yes,
And then, about 6 months later, you listened to another call on February 17th, 2023 at 9:28 a.m. Call that's 190 seconds long. Is that right?
yes,
Okay. Now, I might tax you a little bit. I know it's hard for me, but if you look at the calls that are each 190 seconds long, those 3, and you look at the identifier, it's the exact same phone call. Is that right?
yes,
So the call that you listened to on July 29th, 2022, and on August 7th, 2022, and on February 17th, 2023, was the exact same phone call, right?
yes,
So you listened to the same phone call 3 times over the course of about 8-9 months, is that right?
yes,
And then if you do the same thing for the call that's 169 seconds long, that was on July 13th and August 7th, that was the same phone call, is that right?
yes,
Okay, so you listened to that same phone call twice, is that accurate?
yes,
Okay. So it is the case you listen to 4 phone calls, but you listen to the same phone call multiple times, is that right?
yes. I think I forgot where I forgot where I started, and I started from there.
Okay. Did you made notes about when you listened to these phone calls, didn't you?
No, because I didn't put any notes on the call. And then because I was going back and forth doing other things, I forgot where I was at.
Okay. So you listened to the same phone call 3 times and did not take any notes
No,
of that phone call?
I didn't.
You listened to the same phone call 2 times and did not take any notes of that phone call?
Right,
And you listened to the other calls once each and did not take any notes of those phone calls?
right.
Now, isn't it true that the very first one you listened to, that 169 seconds that you immediately recognized, it was a call between Mr. Crucius and his attorney?
Yes, and I think I turned it off.
You turned it off? Okay. And yet you listened to it again about a month, or actually a few days later, is that right?
Right,
Okay. And then that other call that was 190 seconds, you knew from the beginning there was the same phone number, same attorney that Mr. Cruz was talking to, right?
Right, but it's because I was going through a bunch of calls in different cases. And if I didn't write down what it was, then I went to something else. And I forgot where it started. You know what I mean?
Okay. It would have been easy, had you taken notes, it would help you to remember where you left off, right?
Yes.
Okay. But you didn't do that in this case?
No.
And so that's why you listened to the same attorney-client phone call 3 times, right?
Well, because the way you're asking me, I didn't ask. I didn't hear what you guys said. I heard the call, and then I turned it off.
Okay. You turned it off right when you recognized, whoa, this is his lawyer talking, right?
Yes.
Okay.
And in GTL, I didn't know how the numbers were. I didn't know the numbers of I was just going down one by one by one by one. You know, like it's like a list, and I was just going by the next list, the next list, the next list, like that. I didn't know how the numbers come out.
Oh, the phone numbers?
Yeah.
Okay. So when you first heard that first phone call, the 169-second one, and you realize it's an attorney, you didn't think to look, well, which other ones do we have that are attorneys?
Well, I don't know how they were. I don't know how they, because it was, I didn't really know that system. That they didn't say like, oh, you're going to do this and you're going to do that, and this is how it's going to be this, and this is, they just said, look at listen to the calls and see if they have anything. And I'm like, okay, I mean,
Okay.
it's not genius,
And,
but I guess it is, you know?
and when you open up the website, it kind of shows you the date, the inmate's PIN, right? And the phone number that the inmate dialed, right?
Yes.
Okay. And so you didn't write down that number to think, well, maybe there's other calls that I shouldn't be listening to?
But it's because I didn't know where the numbers were at. I know that it was the name, the PIN, and I think his number, but I don't know where who was calling him.
Okay.
That's what I'm trying to say. Like,
Okay.
I didn't know where the numbers were, you know what I mean?
Okay. So when you looked at these calls, you said that it was pursuant to an attorney telling you to look at certain calls, right?
Yes.
Who told you to look at these calls?
My chief at the time, but it wasn't just his. They asked me to listen to
Ma'am, he asked who is that person?
John Briggs, my chief.
And did you tell John Briggs, actually, I mean, you did tell John Briggs that, hey, these are attorney-client calls right here, right? Because he asked you to look at them, and you had to explain why you weren't able to look at them, right?
No, because he just told me, listen to the calls and see if there's any drugs, any criminal activity, if there's anything that you hear, and then write it down. He didn't tell me about the attorney privilege or that there was attorneys on the calls. I didn't know that.
And isn't it fair to say if he gives you a task to look at calls, I mean, you're going to tell him why you weren't able to complete the task or what you did or did not find? Isn't that fair?
I just told him I didn't see anything.
Okay. You didn't tell him you listened to some attorney-client calls 3 times, right?
No.
Okay.
I just told him I didn't see anything. I didn't hear anything.
Now, is it fair to say that Loretta Hewitt approached you about these calls about September of 2023?
Yes.
Okay. Now, in the state's response, they say the one employee who listened to the calls has been admonished to never discuss these calls with anyone. Was that employee you?
Yes.
Okay. And it says you were admonished, right?
She just told me not to say anything to anybody, and she didn't want me to tell her what I heard. She wanted to protect the whole system and the product. She told me, don't say anything. I said, no, I didn't say anything.
Okay. But you do remember, because you listened to it 3 times, you do remember what those calls had, right?
Yes.
Okay. And you haven't discussed that with anyone at the
No.
office, right? And you did not write down any of
No.
what you heard?
No.
Okay. And it's fair to say it's attorney-client communication that was on those calls, right?
Right.
And you heard things you weren't supposed to be hearing, right?
But that's again, I didn't hear what you guys talked about. I heard the entrance of the call.
Okay. And so to be able to identify who's on the call, you have to realize, wait, this is an attorney talking, right?
No, I thought it was somebody else.
So you listened to it for a bit until it clicked that, wait, this is an attorney, right?
Yes.
Okay. So you heard some of the communication before you stopped listening, right?
Yes,
Okay.
because it was a girl.
Okay. Now, is it fair to say that if that phone number we read matches with his attorney, Corey Harbor, that seems accurate?
I don't know who Corey is.
Okay, would you dispute that?
Well, I don't know the number.
Okay, fair enough. Now, there weren't any safeguards that the DA's office had in place to prevent you from listening to those calls, right? Is that fair?
Fair.
Okay. So when you heard these calls, you didn't communicate with anybody at the DA's office that, hey, we have attorney-client calls that we should not have. Is that right?
Right, because I didn't know it was a thing.
So you didn't raise any concerns with your supervisor, Attorney Briggs?
No.
But you knew now, I mean, you knew then and you know now, that accessing privileged communications can have legal consequences, right?
Yes.
It's pretty serious, right?
Yes.
It could undermine Mr. Crucius's right to effective assistance of counsel, right?
Yes.
And yet, despite all that, your office still does not have trainings on the ethics of handling jail calls. Is that right? You haven't done a CLE in your office about the ethics of listening to jail calls, right?
Well, we've done ethics,
Okay.
but not on the calls, no.
Not on the jail calls, right?
Right.
I can't hear you, man.
No.
Thank you.
And you're aware that listening to privileged calls can lead to exclusion of evidence, right?
Yes.
If it's serious, it can lead to dismissal of the charges, right?
Yes.
Your Honor, I'm gonna object at this time. He's asking legal questions of this witness and not factual
Sustained.
requests.
Sustained.
When you listen to these calls, did you listen to it with a headset or did you listen to it on your computer?
With my set.
Was there anybody else around you when you listened to them?
Well, I was in the middle of everything. My desk was in the middle of everybody, but that's why I used my earbuds.
Okay. Now, the dates that you actually listened to these calls, you didn't write those down on the notepad and put it in the box, right?
No.
Okay. So if, for example, if you would listen to a call on a CD, sometimes you would listen to it and not write down that you listened to it and put it in the box, right?
No. I only write notes if I'm looking for something that I am looking for.
So if, for example, you listen to a jail call off a CD and you don't find what you're looking for, you're not going to write down on your sheet that you listened to it, right?
Yeah, I wouldn't put notes. I'll just put a little check mark on the CD.
Okay. And that's kind of the same practice of all the other paralegals in your office, right?
Mhm.
Okay.
Is that a yes, ma'am?
Yes.
Thank you.
At the time that you started listening to these calls, you knew that Mr. Crucius was represented by an attorney, right?
Yes, 3.
3 attorneys, okay? And so you didn't take any steps to avoid listening to attorney-client phone calls, right, at that time?
Excuse me?
You didn't take any steps to avoid listening to our attorney-client phone calls at that time?
What type of avoiding?
When you were listening to the calls, right?
That I avoided? Or,
So, you knew that he was represented by 3 attorneys, right?
right,
You didn't take each of our phone numbers, track it with what's on GTL to say, okay, I shouldn't be listening to these, right?
right.
And you yourself haven't implemented any changes on listening to jail calls since then, right?
I personally have.
Okay, what have you done differently since then?
Now I make sure that I don't have the attorney's name and make sure that it's not, like I write everything down now.
Okay, so whenever you listen to it now, you write it all down?
Yes.
Okay.
Even
And-
if it's not, I'll put not heard or whatever.
Okay. And so you'll look at the phone number on the GTL website and try to match it with the attorneys, is that right?
Yes, now I do.
Okay, now you know that if it has that, you stay away, right?
Yes,
And it's because, especially in this case, it's a high-profile case, right?
yes,
And you know the significance of this case, right?
yes.
Okay. You have a moment, Judge?
Yes, sir.
Okay, ma'am, so since Ms. Loretta Hewitt notified you of the incident, have you gone to the box to see if the box contains any of your notes of listening to jail calls?
No, I'm not in that case anymore.
Okay, so there may be notes that you put in there, there may not be, you don't know, right?
I could say that from the calls, there's no notes,
Okay,
for sure, 100%.
okay. And you said when you would listen to the call, you would listen for a little bit, hear voices until you realize this attorney. You don't know if you listened for a minute, for a couple seconds, for a few minutes, right?
Right,
Okay, it could have been a long time until you realized, or it could have been a short time, right?
right.
Thank you, ma'am. Past witness, Judge.
Mr. Davis?
Good morning, ma'am.
Good morning.
I just have 2 or 3 questions, actually. You've listened to calls on these recordings. These jail calls, don't every single one of them have a start that says and this is just generally, and you can correct me, something like that says this call may be monitored and recorded? Does that come across on the call?
Yes,
Is that at the beginning of the call?
in the beginning,
And is that on all of these?
yes,
Okay. Now, you said that, if I've got your testimony correct, that once you started listening to a call and understood that, well, this might be an attorney call, you stopped listening to it.
right,
And essentially, once you figured out it was an attorney call, you did not listen to the substance of the discussions between the attorney and Mr. Crucius.
correct,
You just quit.
correct.
And finally, I'll just ask it a little bit different way. These calls that are on that list, the Crucius attorney phone calls, and you said there was a woman's voice?
Right,
And I guess Mr. Crucius, just a male voice, one male and one female?
right,
Okay. All of these calls that are on that list, all of the Crucius phone calls that you listened to, you have not discussed those with any prosecutor in the case?
correct,
You've not discussed it with any investigator in the case?
correct,
You've not disclosed anything to any law enforcement officer
correct,
and no district attorney's office personnel?
correct,
Essentially, what you've done is keep that safe from everybody, correct?
correct.
Pass the witness.
That's 11, not 2 or 3, Mr. Davis.
Your Honor?
That's That's 11 questions, not 2 or 3.
I'm sorry, sir. You know how lawyers are.
I do. You know how judges are. Mr. Valenzuela, any more questions?
Okay, ma'am, so you testified, excuse me, at the beginning of the GTL, there's that recording that the call is being monitored and recorded, right?
Correct.
But even though that's on every call, you stop listening when you realize it's an attorney-client, is that right?
Correct.
Because you know that an attorney-client call is always privileged, right? Is that right?
Now, yes.
Well, you knew it back then because
Well,
you're
yes.
trained, right?
Correct.
Okay. And you don't have any knowledge or information about the DVD that had calls, right?
I didn't know about the CD.
Okay. And you don't know if there's few calls or, as the district attorney said yesterday, hundreds of calls, right?
I don't know.
Okay. It could be on hundreds of CDs, one CD, you don't know, right?
I don't know.
Okay. And when you listen to the call, you said a female, Corey, that you became aware this is an attorney-client call, right?
It wasn't her name. It was a girl. I don't know who her Corey is.
Okay. Whoever
She
the-
didn't say my name is Corey or anything like that.
Fair enough. But when you heard the female speak, you came to realize, well, this is an attorney, right?
When the girl was on the call, no, I didn't know it was an attorney.
Okay. You didn't know that the female speaking at any time was an attorney?
Until she said, I'm gonna call Mr. Mark Spencer. Let me call him, and I was like, oh, and then that's when I hung up.
Okay. And her voice appears on every single one of the calls you listen to, right?
Yes,
Okay. And at the time, you knew that Mr. Crucius was charged on the federal side, right?
yes,
And you knew he had attorneys over there as well, right?
no.
Okay. You
I
didn't
thought
know.
I thought it was still you and Mr. Spencer.
Okay. So you knew that he had attorneys over there, you just didn't know who they were.
I thought it was the same
Okay.
attorneys.
Yeah. And then when the federal case terminated, that's when the state took possession of Mr. Crucius, is that right?
Yes,
Okay. And then that's when you were aware that, wait, there's different federal attorneys as there are from state attorneys, right?
I didn't follow the federal court, so I didn't know.
Okay. So since you didn't know that the female voice was an attorney, you had to listen to the content of the call, right?
Of the girl, yes,
Okay. And you were aware that, I mean, it's all over the media, that the attorneys on the federal side changed at some point, right?
yes.
Okay. All right. No further questions, Judge.
Follow-up questions, or 2 or 3, Mr. Davis?
0, Your Honor.
Thank you. Ma'am,
Your Honor,
you
we ask you that should be subject to recall.
Ma'am, you may step down, go back to work, but if we need you, we'll call you up, and we'll give you plenty of time.
Okay.
What are we doing next, counsel?
Your Honor, we call John Briggs.
Yes. Sir, you have been sworn. Please be seated. For the record, I do need your name. I need you to spell your last name for us.
My name is John Patrick Briggs. My last name is Briggs.
Mr. Spencer.
Thank you, Your Honor. Good morning, Mr. Briggs.
Good morning.
You, of course, know that me, along with Mr. Valenzuela and Mr. Stevens, represent Patrick Crucis on this case.
Yes.
I'm going to ask you just a couple of questions. First, I'd really like to get a little bit of your background and experience on the record. Your education, where'd you go to undergrad?
Stanford University,
Where'd you go to law school?
Baylor Law School.
How long you been a prosecutor?
Almost 30 years.
When you became licensed, did you go straight to the prosecutorial side of
Y-
the bar?
Yes, when I was licensed, my first job in January of 1996 was at the county attorney's office. I prosecuted juveniles for almost 2 years, and then I moved to the DA's office in September of 1997.
Fair to say that you have handled multiple capital murder and murder cases?
Yes.
What's your current position, Mr. Briggs?
I'm a division chief in the office. I'm assigned to supervise the specialized units in the office, the homicide unit, the special victims unit, white collar, the drug task force, the border prosecution unit, and I guess if we get a family violence unit, that will probably fall under my purview as well.
You're unique in the sense that you've actually been a prosecutor through the administrations of Mr. Esparza and Ms. Rosales before you were wrongfully terminated, and Mr. Hicks, correct?
Yes.
When you were working with Ms. Rosales, what was your position at that time?
When Ms. Rosales took office in January of 2021, I was moved to the homicide unit, and Michelle Hill and I were the chiefs of the homicide unit.
And at some point, were you a part of the trial team of the Cruces case?
Yes, when she came into office, I was the only person left in the office with any death penalty experience, and I inherited the Walmart case, Facundo Chavez's case, the one who shot and murdered the sheriff's deputy out in the Lower Valley, and I also inherited Jason Gibson was the third. We had 3 active death penalty cases in the office, and so those became my responsibility.
Your Honor, we move to introduce defendant's exhibit number 7 and defendant's exhibit number 8 into evidence.
No objection. Defense exhibits 7 and 8
May I approach the
are
witness, Your Honor?
admitted into evidence for the purpose of this hearing only. Yes, sir?
Yeah. Mr. Briggs, I'm going to show you defendant's exhibit number 7 and number 8 that was produced to us by the district attorney's office, and I'm going to ask you just to review it. I'm going to ask you some questions about it.
Mr. Spencer, I've not seen these before, so do you want me to read all of these
No, I'm really not
items?
going to
Or
ask you about the orders, Mr. Briggs. I'm going
Okay.
to ask you more about the substantive visitation law of the tax. That's the way it was produced to us, so I'm giving you the whole package of it.
Okay.
And those are the visitation logs, correct?
Yes, these appear to be visitation logs. Well, it appears to be two copies of the same
Correct.
thing. Okay. all
That's
right.
the way it was produced to us. Now,
Okay.
so that's exhibit number 7 you reviewed, correct, Mr. Briggs?
Yes.
I'm gonna ask you to review exhibit number 8. It's got an affidavit by the sheriff's department of what they produced to us as well. And it's basically an expansion of defendant exhibit number 7. Ask me if you agree with that. I'll ask you if you agree with that. Your Honor, for the record, exhibit number 7 consists of 40 pages, and exhibit number 8 consists of 64 pages.
I think I am familiar with a couple of the copies of things that are in State 7. I don't know that, I'd have to sit down and compare 7 to 8 to see if these are, if what's in 7 is also included in 8, but there's a lot more in 8 that
Right.
I don't recall having seen before.
Okay, so let me ask you, is it fair to say that exhibit 7 and exhibit 8 are visitation logs? That is a record of the people that come to visit Patrick Creek. Some of those documents are.
That's what they appear to be, but I assume because they've got an affidavit from the jail that these are their records, that they would be able to tell you that. That's what they appear to be, yes.
And would it be fair to say, from looking at these records, that every time a person goes to visit an inmate, the sheriff requires that there be a sign-in of who is actually visiting that inmate? Are you aware of that?
No, but that doesn't surprise me. And
Well,
I have in the past, in cases, requested visitor logs, so I know that they do keep logs. I don't know any of the mechanics of it, or if there are exceptions or anything like that.
Okay. These visitation logs, there's some notations or handwriting on those logs, on some of those logs, correct?
In States Exhibit 7, there were some annotations in the margins of some of the visitor logs.
States Exhibit 8 appears to have some handwriting as well on.
I'm sorry, Your Honor, just for clarification, are we talking State's exhibit or defense exhibit?
Defense exhibits 7 and 8. I
7 and 8.
Just so
I-
we're clear.
You said states.
I may have said states.
I think he said states too.
I apologize.
Well, we don't need to go back. and ask Natalie.
Defendant's
Let's just-
exhibit.
we're
Just so
doing-
the record's clear, Your Honor.
Yes.
Thank you.
Are you familiar with one of these pages in Defendant's Exhibit number 8 that is a contact sheet visitation?
No.
You're not?
The one that you're showing me that has some
Right.
handwritten notes on the side, no, I'm not.
Do you recognize the handwriting notes on that?
I do not.
Okay, so you don't know who wrote on state, I apologize, on Defendant's Exhibit number 8? Who wrote on Defendant's Exhibit number 8 on those visitation permission slip?
I don't.
Okay. Do you recognize the handwriting on Defendant's Exhibit number 7 that appears on the visitation log? That appears to be a different handwriting from Defendant's Exhibit 8.
I know whose handwriting that is, but not because I look at it, it's like, oh, that's the handwriting of so-and-so, but I know that from looking into these logs, who made those annotations.
And who made those annotations?
Sylvia Chaparro.
Okay, Ms. Chaparro, I think
Yes.
she will be our next witness. Let me ask you, Mr. Briggs, did you review these visitation logs? of the different people that visited Mr. Cruz's?
No.
Okay. Do you know where those visitation logs were?
Most recently, those visitation logs were in my office.
Okay. How long were they in your office?
I don't know. Probably,
Best guess.
well, I don't like to guess. It had to have been probably sometime in 2023 is the best I can tell you.
2023 until when?
Until probably a week and a half ago or 2 weeks ago, when we started looking through the office for documents responsive to the defense's discovery motion.
We had asked requests from the district attorney's office to look in your office to see what other information you may have or documents you may have that had not been produced.
I don't know if they were produced or not.
Okay.
Those documents were given to me by Loretta Hewitt sometime in 2023. I don't remember when.
Okay, can you estimate in what month of 2023?
I really can't. I just know it's 2023 because I came back to the office in 2023 in February. Ms. Hewitt was already there, and I know that she left the office in November of 2023. So it was sometime between February and November of 2023 when she brought those to me. The dates on the visitation logs might be an indication of roughly when that would be. Obviously, they were brought to me after the dates on those logs, but I can't tell you in 2023 when that happened.
So approximately at least a year they were in your office. Did you ever look at those visitation logs during that year that they were in your office?
No, I didn't. Ms. Hewitt brought them to me. I don't remember the specifics of our conversation. She was concerned about these documents. I told her she didn't want them. I said that she could leave them with me, and she did, and I put them, I was busy on other things at the time. I put them with my Walmart materials, and quite honestly, I didn't go back to them. I'd kind of forgotten that they were even there until we started looking for items in the office responsive to the defense's discovery motion.
When Ms. Hewitt gave them to you, because she said you told the court that she was concerned.
Mm-hmm.
She had a concern that maybe the district attorney's office had in its possession documents that it should not have. Is that fair?
I don't remember that being the conversation. I just knew that from what I recall, she was upset. I wasn't exactly sure why. I didn't really have the time to delve into the matter at the time. She handed them to me. I looked at them. I'm like, okay, they're visitor logs. That's not out of the ordinary for us to have visitor logs. So I set them aside, and then I didn't ever get back to them.
Is it your position that the district attorney's office has the right to look at the visitation logs to determine who visits the client, whether it's one of their experts, whether it's a lawyer, whether it's a consulting expert, a testifying expert? Do you feel that the district attorney's office has the right to have that information in its possession?
Yes.
Okay. So that's why you said it's been your practice to do that in the past, correct?
Yes.
Okay. Can you see the concern that the defense would have for the district attorney's office to have, to be able to track the lawyers that see him, how often they see him, the experts that go see him, when at this time the district attorney's office is not entitled to know who their experts are?
Well, that's kind of a lot to unpack. I see your concern, but no, you're not entitled to keep that information secret.
Okay. And that's your position of your understanding of what the law is that correct?
That is what the law is.
That's your position of your understanding?
That is what the law is.
All right. Well, we'll certainly let the courts decide what the law is as opposed to what you believe the law is, correct?
The court is going to make a decision regardless of what the law is.
You're certainly not suggesting the court is going to make a decision contrary to the law, are you?
No, I'm not suggesting that at all, but I would be lying to you if I said that I'd never seen a court make a ruling that was contrary to the law.
Sure, we've seen that.
We've all been victim of that.
That's correct,
So-
that's correct. So if I understand your testimony, Ms. Hewitt, when she came to you with a concern of these visitation logs that was in their possession, what was the hierarchy at that time? Were you her supervisor? Was she your supervisor? Explain to me at that time what the hierarchy was in the district attorney's office.
Well, the hierarchy in the office, obviously, Mr. Hicks is the DA, is at the top of the food chain. Below Mr. Hicks is Ballard Shapley, the first assistant, and then below Mr. Shapley are the various division chiefs in the office.
And are the various division chiefs equal?
Yeah, as far as I know,
Okay.
yes. There's a division chief over the intake section, there's a division chief over appeals, and then there are 3 division chiefs over the trial section, one over the misdemeanor section, and then Penny Hamilton and I split the duties over the felony section. She has the courts and I have the specialized units. And Walmart, I guess I neglected to mention that earlier. Walmart, being kind of a specialized prosecution, needs to have a pathway to the boss through the office. Ms. Hamilton is not allowed to be in that chain of command because she is a potential witness in this case. And so the duty fell to me to be the division chief over the Walmart team that was working on the case.
So during that year that this information sat in your office that you kind of forgot about, is what you told us, were you not working on the Walmart case at all?
My work on the case has been, well, let me put it this way. I'm not involved in the day-to-day workings on the case. I'm not involved in what Ms. Hewitt was doing when she was there. I'm not involved in what Ms. Tarango is doing on a daily basis. We have Walmart meetings. We discuss what's going on. I'm a part of those meetings. I consult or am consulted to the extent that they want to hear what I have to say about things with regard to the Walmart case. But if Ms. Tarango has problems or concerns or issues, she can come to me with them, and if need be, I can run them through Mr. Shapley or directly to Mr. Hicks.
On October 11th of 2022, were you still working in the district attorney's office?
No.
You had already left, you had already been terminated wrongfully by then?
Yes.
During the time that you were in the district attorney's office, you've received correspondence from Mr. Valenzuela or Mr. Stevens or myself of certain requests. Is that a fair statement?
I can recall receiving emails, mostly from Mr. Stevens, I think, with requests for discovery items.
You respond accordingly?
Yes, eventually, yes.
Eventually, because you're busy.
Eventually, yes. I'm talking mostly about probably in 2021, when I was the homicide chief and I was working on the capital murder cases. But then after about mid-July or so of 2022, I was not working actively on Walmart any longer.
Is it your position that all phone calls from the jail, even if they're with an attorney, is phone calls that the district attorney's office is allowed to listen to?
Yes.
So your position, your practice has been that if there's an attorney-client phone call that's recorded at the jail that comes into your position, the prosecutors are allowed to listen to you?
I would answer that this way. Someone in custody in the jail, state custody, federal custody, doesn't matter. The case law is very clear. Their rights to privacy basically don't exist. And phone calls coming out of the jail are recorded, and everybody knows that. In fact, at the beginning of the phone call, it says, this phone call is being recorded. Okay, could be monitored, it's being recorded, which means that the way I see that, first of all, I don't know why any attorney would speak to a client on a phone call that's being recorded and expect that they have any right to privacy in that conversation. Okay, I understand the attorney-client privilege and all of that stuff, but at the point that you have that conversation in front of a third person, you're waiving that attorney-client privilege. If that phone call is being recorded, that means I can listen to it. And you should not expect that you have any privacy in that phone call. There's a way to make those phone calls that are not recorded by the jail. But if you're going to talk on that recorded line where it says at the beginning, this phone call is being recorded, in my estimation, you are waiving the attorney-client privilege by continuing to talk. And I don't know why anybody would talk under those circumstances. So do I have the right to listen to that? I think yes, because the people were warned, these phone calls are being recorded, and I have access to them, and I can listen to them. Now, let me just say that as a matter of course, when I run into phone calls, which happens extremely rarely, that are between attorneys and their clients, I typically don't listen, okay? It might be constitutional, but it's not Christian, okay? So.
Object to, non-responsive to everything, but yes, Your Honor.
Overruled.
Well, Mr. Briggs, thank you for the way you answered I'm sure you got everything you wanted out.
Well-
But you are aware that those phone calls, that recording that comes out, neither the lawyer nor the client has any discretion or ability to eliminate that disclosure, that waiver.
Which is why those discussions shouldn't be taking place on those phone calls.
Maybe you didn't understand my question, Mr. Briggs. Maybe it was too complicated. It's real simple. You understand that neither the defendant or the lawyers have the right or the ability to change any of that waiver or that pre-recording.
Yes, I understand that. You do not have the ability, nor does your client, to opt out of the recording.
And you're aware that, or are you aware, that during COVID, when it was difficult to see clients, that some lawyers made arrangements with the jail to have attorney-client conversations that are not recorded? Are you aware of that?
I am aware of that, yes.
Okay.
And that was a
So,
very special.
and even under those circumstances, that waiver or that disclaimer still comes out under those calls, but that was set up so specifically with the COVID issue, and specifically because maybe some lawyers wanted to set up an attorney-client conversation. Are you aware of that?
I'm not, well, the short answer is no. I know that
Okay.
there were special rules in effect during COVID because the jail was restricting attorneys' abilities to go physically visit with their clients.
Right.
So we were left with nothing but the phone calls. So now, I think we were attempting to not record those calls, not hand off those calls so that attorneys could have confidential conversations with their clients because they didn't have the option to go see them physically. And so, yes, I know accommodations were made. I don't know if the warning was removed or not, but I think what the jail started doing is they started blocking the recordings of calls to certain attorney phone numbers.
You testified to the court that typically you don't listen to an attorney-client phone call when you become aware of it. So that tells me that typically you don't, but sometimes you do. Is that fair?
No, I should be clear. If I determine that, oh, this is a phone call to their attorney, I just stop listening. Okay, not because I have to, but because I think it's the right thing to do.
You think it's the right thing to do?
I think that was why I said it's constitutional for me to listen, but it isn't Christian. So, yeah.
Did you instruct Ms. Hernandez to listen to phone calls out of the system specifically related to Mr. Cruz's?
I don't remember a specific conversation, but I probably did. That's typically one of the things I ask paralegals to do on bigger cases is listen to phone calls from the defendants.
Okay. When you had what exactly was it that Ms. Hewitt gave you?
When I flipped through Defense 7, I've not seen any of those orders on there. There are pages in there that appear to be kind of like a grid, like you would fill out. And there were probably about a dozen pages, maybe. I don't know, I didn't count. The majority of them were these kind of grid sheets that had a name and probably a date and a time. I don't know what's on there. They look like jail logs of people who've come to visit. Like if you go and there's a clipboard and you put your name and your information, and it was just some full pages of that. And then she gave me, at the end of that, there were, I believe, 2 pages that had, and I don't know what they are. They look like photocopies of a slip that's about less than half of a page in size, and I think there were 3 of those. I don't know what those are. I assume that's related to jail visitation paperwork. So it was about a dozen pages. So in Defense 7, it's the pages that look like what you would expect to see in a jail visitation log, and then 3 slips that are after that.
And you tell the court that when she gave it to you, in the year that it was in your office, you never looked at it?
No, I never. Okay. I looked at it, obviously, but I did not go through it or try and discern what was there or what it meant.
You didn't know, you're telling the court you did no analysis of the information that was in there?
Correct.
Okay. When you assign Ms. Hernandez a task, she reports to you based on the assigned task you gave her, correct?
Yes.
Okay. Do you recall her reporting to you specifically on the calls, on the Cruz's calls?
No, she never did. And typically the way that would work is I would ask a paralegal, listen to the phone calls, tell me if I find anything good, you know. So she didn't ever come to me and say, oh, hey, you know, I listened to this phone call and it's got the smoking gun in it or something like that. So that would typically be why she would come to me. But
you don't know who had access to these logs before you received them in 2023, correct?
the written jail logs?
Yes, sir.
No, I don't. I just know that Ms. Hewitt brought them to me.
Okay. Did you ask her where she got them, how she got them, when she got them, anything like that?
No, I didn't get any of those details. But again, it's because I didn't, at the time, nothing struck me as out of the ordinary. So I didn't ask those kinds of questions because it wouldn't have been out of the ordinary for us to get jail logs.
There are some notebooks that have been missing, Ms. Hewitt's notes that she had. Do you have any of those notepads?
No.
Okay. Did she give you any notepads, or did you only receive what you've identified as recognized as the visitation logs?
I did not receive any notepads from her. The only thing that she brought me were those visitation logs.
Were you present when Ms. Hewitt was escorted out of the office when she resigned?
Present? I was at
question.
I was at work that day.
Okay.
I knew that it was happening. I was not physically present where her office was located to see that process of her leaving.
Yeah, thank you. That's really what I meant to ask you. So you weren't part of the escort team or that escorted her out? Or were you in her office to see what she took or what was left there?
I don't know that she was escorted out,
Okay.
but, and no, I was not there to see how that all transpired.
Did you have a prior conversation with Ms. Hewitt about why she was resigning the office before she resigned?
Sort of, I think. We discussed that she was trying to get a meeting with Mr. Hicks. And I remember this was if this hadn't all happened around Thanksgiving, I wouldn't remember this, but it was that really short week that we had right before Thanksgiving in 2021, when we are typically, just swamped with stuff because it's a short week. We've got 3 days For some reason, the courts want to pack a week's worth of stuff into those 3 days, and we were running around like crazy. She was trying to get a meeting with the boss, and there was one scheduled for Monday. It didn't happen, and I just remember she was very upset that that meeting did not happen. And it was immediately after that that she turned in her resignation, which, if I recall, reflected some of her displeasure.
And the meeting that she was trying to get with the boss is Mr. Hicks, is that correct?
Yes, I mean District Attorney Bill Hicks.
Yes. Are you actively working on the Walmart case now, Mr. Briggs?
Yes, I suppose.
You say you suppose?
Well, I'm not, like I said, I'm not involved in the daily, workings of the case. I do consult with the attorneys with some regularity. I do know what's going on with the case, what we're doing, but I'm not the person actually doing the work.
Did you have any conversation with Ms. Chaparro about her writings on those visitation logs?
No, all I know is that when I found them, I noted that there was handwriting in the margins, and it was in blue ink, which tells me it looked like that was someone's original writing on the side of those. And I took those documents to Ms. Tarango to inform her that, hey, I've got these things, and this is probably related to the defense's discovery motion. And I said, and there's writing in them, and I don't know whose this is. And so we did a quick little ask of, does anybody, who is this? And it turned out that it was Ms. Chaparro.
Okay, so that's how you determine.
That's how I know, if you will.
So it was just recently that you provided those to Ms. Tarango and told her, hey, the defense may be looking for these, and here they are.
Right. It was after your motion, and then the hearing we had, and the judge's instruction that we were to go look for, documents responsive to the defense motion. And that reminded me, oh, hey, I may have something that Loretta had given me, and I went to go look. I'm like, hey, these appeared. Now I understand, what this is in relation to the defense's motion. And so I took it to Ms. Tarango.
How much more information or discovery did you have in your office relative to the Walmart case besides what Ms. Hewitt gave you that she didn't want possession of?
I don't maintain any Walmart-related materials in my office except for a very small number of items. None of them are related to the discovery in the case. I'll tell you, I have the notebook of the information that the defense provided to the state with regard to the defense's experts.
Mitigation?
The mitigation, yes, I have that in a notebook. I have some research and documents related to charging capital murder. I have some a memo that was drafted regarding case law on change of venue in case that becomes an issue. I have the defense's proposed jury questionnaire. I have an Odyssey printout of when Mr. Crucius came back to state custody from federal custody in July, when he was written back over. I believe that was July 11th. And then I have a El Paso Times, like the actual newspaper article of, I believe, when they reported that Mr. Crucius had decided to plea in federal court. Probably my mother gave that to me. I think my parents are the only people left that actually physically get the El Paso Times.
Okay, Mr. Briggs, I got to ask you this question. If you had some documents that Ms. Hewitt gave you that you had in your office for about a year, and you knew she was upset or she had concerns about those documents, so you took it off of her hand, and you're not really active hand-to-hand working on the Walmart case, why didn't you turn that over to Ms. Tarango or to one of the other lawyers that was actively working on the case?
Because I forgot that I had them until we started tearing apart the office looking for documents in response to the court's ruling at the last hearing.
Well, I understand you forgot, but when you initially got them, why wasn't your first reaction, instead of putting them in your file next to what your mother gave you for the newspaper articles, why not turn it over to the trial lawyers that are actually working on the case actively?
Well, because Ms. Hewitt was in charge of those lawyers. It would not have made sense for me to turn around and give them to Ms. Tarango, because they were coming to me from Ms. Tarango's chief at the time. So this was stuff that was coming up the food chain, if you will. So I was taking it from the chief of the Walmart prosecution. It wouldn't have occurred to me to go run to Ms. Tarango with them, because Ms. Tarango was reporting to Ms. Hewitt.
Okay, so when Ms. Hewitt left,
Right.
after she couldn't get her appointment with Mr. Hicks,
Right.
why didn't you at that point turn it over to her, since Ms. Hewitt long ago, just you forgot?
At that point, it wasn't in my mind that I even had those documents still in my office.
Can I have a moment, Your Honor?
Yes, sir.
Since it's your opinion that it's proper for a prosecutor to listen to a phone call that's recorded between a client and his attorney, is that the same instruction you gave Ms. Hernandez when she's listening to the calls? That is, you didn't filter her and say, don't worry if it's an attorney call, because if it's recorded, you can listen to it?
I'm going to disagree with your use of the word proper.
Okay,
Okay.
go ahead.
Legal, I think it's legal.
Okay.
Okay. No, I did not give her specific instruction. I told her, listen to the phone calls. Okay.
That would be all
Because-
the calls.
Would have been all the calls, right.
Did she, how did she report to you what she found in the calls?
I never got any reports from her that she had found anything that I would have been interested in.
Well, Mr. Briggs, in the past, you and I have had lots of cases against each other where you will disclose, oh, by the way, here's the recorded phone calls that your client made, and we intend to use them in trial.
Right.
Correct. So how does a paralegal report to you when they find something like that? How do you know about that to be able to tell us?
Usually because they're waiting in my office first thing at 8 a.m. When I come in and, ooh, you won't believe what I found in the phone calls. You know, that's how I get alerted to it. I come into court and I present them to you, and I take credit for all of that, like I found it. But no, if the paralegals don't come to me and say, hey, I found this person saying something really damaging to their case, then I typically don't know about it. So, I mean, the paralegals, when they listen to somebody and they're making some kind of confession to having done something, or where they hid something or something along those lines, I mean, they know that's important to us and our prosecution of the case. And so I'm dependent on them using their judgment in what is important to the case, and then they come and they bring it to me.
That's when they come to you with an aha moment.
An
That's
aha
what I
moment,
found.
yes. I didn't have any aha moments from Ms. Hernandez.
Kind of like us when we said, aha, the state's been listening to our phone calls, right?
Right. One of those.
Pass the witness, Your Honor.
Mr. Hicks?
Mr. Briggs, regarding the visitation logs, did the state gain any admissible evidence or anything that led to admissible evidence for the state? Or did the state gain any tactical advantage from those visitation logs?
I'm going to have to say no, simply because they were just shelved in my office from probably right after the time we got them to just a week or week and a half ago, and we haven't done anything, investigated anything or obtained anything based on whatever's in there, because I don't think anybody has actually gone through them and looked at them.
Mr. Briggs, let's talk about case portal.
Okay.
Regarding the Walmart case, how is case portal different now versus when Walmart was initially loaded into case portal?
Well, as we have talked about in here on many occasions, the Walmart case is very voluminous. Voluminous like nothing I've ever seen. And our case portal system, which is how we allow defense attorneys to view discovery in our cases, really was not able to handle the size of the Walmart case. And so we undertook to find software from third parties to handle the discovery. There are companies who have discovery software products available. I imagine they have a great deal of business in the civil world on extremely large civil cases, class action suits, things of that nature. And we began exploring the possibility of using one of those software packages to handle the Walmart case. This is one of those, not really we, but other people, not me so much, started looking at these software packages. I remember it fell mostly to Ms. Tarango. Ms. Hewitt was involved in that somewhat. We did not find any software packages that we liked, that were what we needed, and that would accommodate our needs on the criminal side. These are pretty much geared towards civil litigation. So we requested from our IT department, the county IT, to basically fix the portal to accommodate the Walmart case. And their solution was to basically put the Walmart case on its own server, on its own little mini version of the case portal. And so now that's how we are able to access the volume of material that's involved in this case, because it's running on its own separate case portal server and with restricted access.
Let's talk about restricted access. What does that mean?
Before, when we were struggling to use just the regular case portal to access the Walmart case, we asked IT, the county IT, can we lock this case and only make it available to certain users? And the answer to that question was no. We could not lock it. And so, that was obviously one of our concerns, but we did not have the ability to restrict who accessed that case. I know that when Mr. Esparza was in office, we were instructed, if you don't have any business in the Walmart case, stay out of it. Okay, and because we can and did periodically run reports on who had accessed the case, but there was no way to restrict the access. That continued under Ms. Rosales. I told the office, if you don't have any business, stay out of it. And then I believe twice, I think during Ms. Rosales' tenure, I ran a report to see who was accessing the case, found that there were a couple of misdemeanor clerks that had no business really poking around in the case. Some brand new attorney hires that went in there. And I went to those people directly, told them, don't do that again, ever. Don't be poking around in that case. Send another reminder, hey, stay out of the case. That problem was alleviated after you took office and we moved Walmart to a separate server with restricted access.
So now only designated people can access the Walmart case?
Yes, only those people that have a need to be in the Walmart case have access to it.
Okay. Let's talk about the individual folder where they contained what potentially was attorney-client communication. You familiar with that folder?
Are we talking about the phone calls?
The phone calls.
A little bit, yes.
Okay. So what is the structure of portal that would get us to a folder that would hold what was potentially attorney-client communication recordings?
When you log into the portal, there are a bunch of, I guess, menu items that go down the left side of the portal that give you access to various things. One of those is like law enforcement reports. I can click on law enforcement reports, and then it opens up all the law enforcement supplements, and those are further subdivided now into agencies and things of that nature. With regard to the phone calls, there's also a media tab in the portal, and I can click on media. That opens up subfolders that have audio files, video files. There's more in there than just audio and video, but as these are recorded phone calls, they would have been in the audio file. So I go to the portal, I go to media, I go to audio files, I click on the audio file folder, and then that opens up. I think the last time I was in there, there are, well, I don't know how many exactly audio files. The audio files then are listed down the page, and each page, it scrolls for a little bit. So you scroll down, and it continues to list calls. There are probably 40 files per page. And then when you get to the end of the list, you can click on the next page and it'll open up the next 40. And I think there's 3 pages of audio files in there.
Over 100 audio files.
Probably, yes.
And those would be like all the 911 calls, things along those lines?
I'm assuming those are in there. The files themselves are not labeled. Unfortunately, one of the limitations of the portal is our ability to label things. And unfortunately, the case portal, it pulls information from some other sources. Like it pulls police reports straight out of the police computer that makes those reports. It pulls the photographs from the police server. When we get audio files, they come to us as basically just numbers and letters and gibberish that doesn't really identify what it is. And we upload those, and so it's 3 pages of over 100 files, but I can't look at what's on there and know what any particular call is. I literally have to click on it and open it and listen to it to figure out what it is.
There's no way to scroll down and look at, oh, this file's labeled attorney-client call.
Right. Yeah, there's no that says, listen to this one first. This is attorney-client, conversation. No, there's nothing like that.
Okay. You mentioned that we can run a report and see who has accessed the Walmart case. Can we run a report and see who has accessed the individual folders?
I think, from what I recall, that the report will tell me who accessed the cause number, and it'll give me a date, and I believe it tells me the length of time that they were accessing that cause number, and it may tell me the folders. I want to say it does tell me the folders, but it doesn't go any farther than that. I cannot tell specifically what items within the folder have been accessed. Like I can't say, oh, they looked at this autopsy photo numbered whatever on this page of the thousands and thousands and thousands of photographs. But I can tell that they went to the photographs folder.
Okay. Let's move along. Let's talk about Loretta Hewitt. Ms. Hewitt, you were her direct supervisor?
Yes.
And I understand that you participated in strategy meetings on the Walmart case?
Yes.
Was she present in those meetings?
Yes. So, most, if not all, yes.
Over the course of employment with the office, over the course of her employment with the office, did you have an occasion to evaluate her management skills regarding those attorneys that were assigned to work with her?
I'm not sure what you mean by evaluate. I don't recall if, I never performed a written evaluation of Ms. Hewitt because I don't believe she was in the office long enough, but I was aware of her management of the attorneys that were assigned under her on Walmart case.
Did you receive feedback from the attorneys that she supervised?
Yes.
And when she turned in her resignation in late November of 2023, what was your opinion regarding whether or not the district attorney's office should attempt to retain her or go ahead and release her?
I was not in favor of retaining her.
Let's talk about attorney notes. Mr. Spencer went through some of your background in the law, mentioning that you have prosecuted capital murder cases. Any idea how many trials you've had?
I have had, including bench trials, just over 200.
I assume then that you're fairly familiar with the practice of taking notes when you're interviewing witnesses.
Yes.
If during an interview a witness says something that is exculpatory or otherwise beneficial to the defense, what is the standard way to handle that practice?
I think the standard way to handle that is you send a notice to the defense of whatever that information is and whatever the circumstances were under which it was obtained, such as the date, where it took place, who was present, and the nature of the information that you're turning over. And that's typically how that's the standard practice here in El Paso.
Is there some scenario in your mind where it would be standard to just turn over all of your written notes to the defense attorney?
No.
What is your opinion regarding a prosecutor who says that they would turn over all of their written notes to the defense attorney to allow the defense attorney to make a judgment call on whether or not those notes contain beneficial information to the defense?
Well, that is certainly not how I would do it. But I think that is certainly more than is required under the law. And it's unnecessary if the prosecutor is fulfilling their duty under 3914 and Brady and its progeny and 3.09 of the disciplinary rules. There is a way to turn information over to the defense that they are entitled to have that does not involve just wholesale handing over your work product to the defense. So I would want to know from that prosecutor why they felt like that needed to be done in a particular case. But to do that as a regular course, I don't understand that.
Have you had occasion to, while in the course of interviewing witnesses, discover things that you felt needed to be disclosed to a defense?
Yes.
And what have you done when witnesses have said things that you felt was exculpatory or otherwise beneficial to the defense?
Typically, I either put it in a letter or an email something that I can document in writing that I have turned over the information to the defense. So that's typically how I handled those things, and it's not uncommon for that to happen.
Are you aware that Ms. Hewitt claims to have left behind after her departure some 4 to 5 yellow pads or notebooks, notepads in the office?
Not until Mr. Spencer was questioning me about it, but
Are you aware of the efforts that the office went through, in particular Mr. Rongo went through in reviewing, cataloging everything in Ms. Hewitt's office?
I'm not aware of the exact extent to which that was cataloged or detailed.
Let's talk about attorney-client phone calls. So that we're clear, did Maela ever give you any feedback regarding her having heard any potential attorney-client phone calls?
Okay, you're asking me about Maela Salazar?
Oh, I'm sorry. Let me go ahead and clarify. Did any paralegal, anyone in the office, give you any feedback regarding having heard any potential attorney-client phone calls?
No.
Are you aware that there's a procedure at the jail for inmates to make a phone call to their attorneys that is not recorded?
I was surprised to learn it, but yes.
You're aware that the jail pulls an inmate out of his cell, takes them to a private area for that phone call?
I believe it's the law library, yes. They can make a call from a line that is not recorded on the GTL system.
Additionally, are you aware that the jail does not restrict attorney visits? That those attorney visits are never restricted?
Dangerous to use the word never. I would agree with that, except that, in COVID, that was actually the case. They were physically prohibited. But absent extraordinary circumstances like a pandemic, then yes, the jail does not restrict in any way that I'm aware of an attorney's ability to go visit with their client. If it is, it would have, barring, pandemic, it would have to be because of some kind of, safety concern that the jail has. That's their priority, so.
Barring a safety issue at the jail, sure.
Right.
One moment, Charlie.
Yes, sir.
Just so, are you aware whether or not there had been an actual order signed that allowed for attorneys to see their clients at the jail during COVID?
I'm sorry, what was the question?
Were you aware that an order had been signed allowing attorneys to go to the jail during COVID to see their clients?
No, I'm not aware of any such order.
All right, very good. Pass the witness.
Mr. Spencer?
A few more questions, Mr. Briggs.
Just a few?
Not 2 or 3 like somebody else said earlier.
I was waiting for him to put a number on it, because.
No, I did, I put no number.
Okay.
You indicated under examination by Mr. Hicks that you were not aware about the 4 or 5 notebooks Ms. Hewitt had left in the office until I mentioned it to you, correct? That was your testimony?
Right.
So nobody in the DA's office told you, hey, we're looking for Loretta Hewitt's notepads. Do you know where they're at? Have you seen them? You knew nothing about those missing notepads until I brought it up?
Well, no, there was I think late yesterday, there was another effort to go through items in the office.
Sure. Other than the last few days, prior to the last few days, there was radio silence in your mind about the missing notepads.
Yeah, I didn't know that there were notepads or that they were missing until just, I guess, late yesterday.
And although you've been involved in the case from the very beginning, even to now, nobody in the district attorney's office said, John, have you seen any of Loretta's notepads? Within the last, absent the last 48 hours.
No, but I'd already made it clear to, I know Ms. Tarango and probably Mr. Davis exactly what I was in possession of with regard to Walmart, and it doesn't include any of Loretta's notes, so there would be no reason for them to come ask me for that.
And you talked to Mr. Hicks about the fact that the way you would have handled exculpatory or Brady or mitigating is you would tell the defense lawyer, I interviewed a witness, they told me something that is perhaps exculpatory, and this is what it is, correct?
Yes.
As opposed to your notes of what you took for your contemporaneously were interviewing or pre-trialing that witness, correct?
Yes, because my notes isn't what would be available to you to use to impeach that person at
Well, Mr. Briggs,
trial.
Would it be fair to say that you as a career prosecutor will look at a witness statement very different from what a defense lawyer will look at it? Would you agree with that statement?
No, I would not.
You think that prosecutors and defense lawyers look at the statement and they're on the same page exactly what that witness said?
I think good prosecutors, yes. When I look at a witness statement, I look at it for what's good for me, and then I put on my defense attorney hat and say, if I was the defense, what would I do with this statement? And I look at it in a, how can the statement hurt me as a prosecutor if I'm in defense mode? So, no, I look at statements, what's good for me and what's good for you. And I think that's what good prosecutors do.
And when you said you put on your defense attorney hat, you've never been a defense attorney, have you?
No. I've gotten to play defense attorney a couple times.
In mock trials?
No, actually, I was actually thinking about Daniel Villegas, but because since you had the burden on that writ, I got to play defense attorney. So it was basically just go in and complain about everybody and everything and see what happens.
It didn't go very well for you, did it?
It went fine for us on the writ.
Did it?
Yeah.
The transparency that I want to talk about, you don't see that you to have full transparency would be if you're interviewing a witness, and that witness says something exculpatory, give those notes to the defense lawyer, and we have full transparency as opposed to your interpretation of what that witness said. Do you see that issue?
I'm not aware of the Code of Criminal Procedures section that deals with full transparency.
No, you are aware that the code calls for prosecutors to do justice, correct?
To see that justice is done, yes.
And prosecutors should not hide evidence, correct?
That's true.
Right. They should not manipulate evidence, correct?
Absolutely. But there are rules that deal for how I turn over things that are beneficial to you. That's my duty, is to comply with those rules.
Sure. Your interpretation of how you think that information should be related to a defense lawyer.
No, I don't think it's open to much interpretation. Something is good for you or it's not.
Okay. Mr. Hicks asked you about the fact that when Loretta Hewitt resigned, if you were in favor of retaining her. Well, she resigned. She wasn't asking for a job. She resigned. She's telling the office, I'm out of here. So it's not a question of whether the office could retain her, because she didn't want to be retained or did not want to work for the DA's office. Is that fair?
Well, the question I took to mean, and because this is not unheard of, sometimes when people turn in their resignations, I have talked to people after receiving a resignation to talk to them about that decision. And there have been instances where people have changed their mind and decided, okay, you know what? I'm going to rescind that and I'm going to stay. And we have engaged in that over the last couple of years. When people resign, we sit them down. What is it? What's the problem? Is this something we can fix? Is this something we can change? What would we need to do to make you stay? If it's something we can accommodate, then maybe we do. But that discussion was had, And I was not in favor of reaching out to her to try and talk her into staying.
So is there an evaluation done on Loretta? Was there an evaluation done by the office?
No, there wasn't, because your first evaluation is done on the first anniversary of your employment with the office. And my understanding, I know she was there when I came in February of 2023, was that she was hired by, from what I recall, she was hired by George Alhana in that weird period where Ms. Rosales had already decided to resign, and Mr. Alhana was kind of running the office, and he made an offer to Ms. Hewitt to come work at the office. And so that offer had been made, and Mr. Hicks, when he came in, honored that offer and allowed Ms. Hewitt to come work at the office. But Mr. Hicks did not hire her. She was already, or had been made an offer before Mr. Hicks took office.
Are you sure about the fact that Mr. Hicks did not hire Loretta Hewitt, Mr. Briggs? I want you to be accurate about that.
Well,
I want you to guess.
Well, okay, I was not employed in the office at the time, but my understanding is that she had been brought, she was attracted to the office and made an offer before I thought Mr. Hicks took office. But if I'm wrong about that, he can correct me on that.
You're not sure. Would that be fair?
I wouldn't bet my left arm on it.
I wouldn't either.
Okay.
I want to talk to you about, Mr. Hicks, one of Mr. Hicks' questions to you about that is there any tactical advantage to looking at the visitation logs? You remember that question?
Not specifically, but we can
Okay.
talk about that.
Well, yeah, I wrote it down, and you correct me if I'm wrong. I thought Mr. Hicks asked you, is the state receive any tactical advantages to having access to the visitation logs? And I thought you said no. Do you recall that?
Right.
Okay. So you're in agreement with the statement that you believe there's no tactical advantage by looking at the visitation logs of who visits Mr. Cruz, correct?
Right. That's going to have next to no bearing on this case, or this trial.
Okay.
Anyway.
Well, if, for example, some of the visitors to Mr. Cruz's were experts, consulting experts, maybe even testifying experts, that you, at this time, are not entitled to know who they are. Because you do know that the law dictates when the state is entitled to know who our testifying experts are, correct?
Yes.
Okay. And by looking at the visitation logs and seeing the different experts, psychologists, psychiatrists, nuclear radiologists, whoever may have come to visit him, right? Then the prosecutors can then Google and determine who these people are and what potential strategy the defense is doing by having all of these experts visit the client. You could do that, couldn't you?
Except that you've already given us all of that information.
You could do that, couldn't you, Mr. Briggs?
Yes, I could if I hadn't already gotten all that information from you.
Yeah, but you don't know if the information you got is everything of all the people that visited Mr. Cruz's, do you?
That's true.
That's right.
But
So that, well, hold on, let me finish my question. So you have a tactical advantage of being able to do research on what the defense potential strategy is by looking at those visitation logs. Isn't that true?
no, I get to research and find out about the people that are going over there. What you intend to do with those people is still up to you and your team.
That's right. But by knowing who they are, it could allow you to start preparing for potential rebuttal experts. Is that fair?
But I already know who they are.
Is that fair or not, Mr.
Yes, that's fair.
All right. We're trying to be fair, aren't we? I know it's hard, but you can try to be fair.
Can I object to his sidebar, Your Honor?
I'll object to the sidebar.
Okay, all right.
So, to be fair, a prosecutor,
Fair as you define fair.
Let's wait for an answer, a question.
wouldn't it be fair to say, Mr. Briggs, that a prosecutor who knows the defense experts that are coming to consult with the client over a period of time could then do research on those experts and make a determination as to what the potential strategy is for the defense? Yes or
It's not yes or no. The answer
Was
is...
the question confusing?
No, the answer is it makes no difference in this case.
Say it again?
It makes no difference in this case.
It may, no, in this is the case that you thought it was okay to do that.
Now, when we were talking about the items that I maintain in my office, one of those items is all of the expert stuff that you gave to the state about your experts' analysis and investigation, and you provided that information to us already.
Then maybe you didn't understand the previous question. But you don't know if what we gave you is all of the people that visited Mr. Cruz's,
Right.
correct?
Right.
All right. So if there's other people there that visited Mr. Cruz's that you were not aware of, that we didn't disclose to you, you would have a tactical advantage, wouldn't you?
That information's not, you're not entitled to keep that information secret.
You're not entitled to what?
To keep that information secret.
You're not entitled to know that information at this point in the litigation.
No, I disagree. If the jail is going to keep a log of everybody going in and out of the jail, and you send your expert to go see them over at the jail, then there's going to be a record of that, and I'm going to find out about it.
Actually, the Supreme Court has addressed that issue, Mr. Briggs.
Okay.
Because when a defendant is indigent, right, he is at a disadvantage of who can visit him and how that's recorded and how that is disclosed to the state. So the Supreme Court has recognized that disadvantage that an indigent person has, as opposed to someone that's retained, that's out of custody, that can visit all of the experts without the state requiring, an extension of the state, the jail, required to everybody sign in and disclose who they are.
Which is exactly why it's a routine practice here in our community for defense attorneys to arrange those visits to take place here in the courtroom with the permission of the judge, to where experts don't have to go sign in over at the jail. The defendant is brought to the courthouse and brought usually to a jury room to meet with the defense expert, and it doesn't require a defense expert to sign in over at the jail.
But if the court doesn't allow that, or if there is an issue that the jail doesn't allow that, that would be a problem, wouldn't it?
I have never heard of a court denying that request to the defense, and even if the jail was not in favor of it, the jail will always be responsive to an order of the court ordering the jail to bring the defendant to the courtroom.
Let me ask you, Mr. Briggs, about the portal that we talked about a little bit earlier.
Okay?
There's no way of tracking, or is there a way of tracking everybody that gets on portal and what they look? And I think what you talked to Mr. Hicks about is that you can determine when an attorney actually views certain items. Is that correct?
From my experience, what I have the ability to do is I can take a particular cause number, and then I can ask for a report of who has accessed that cause number. So I could do it for every single case in the portal, but I have to run those searches, I think, based on a cause number. So it's kind of a tedious process. We don't do it except in very large cases such as this.
So portal allows the prosecutors to track what items a defense lawyer is viewing.
No, not the defense. I'm talking about who's accessed it from. We run reports about who's accessed it from our office.
From your office only?
I don't, in the reports that I've looked at, they don't include information about when the defense has accessed anything. I don't know that I have the ability to find that out.
Yeah, you're not sure, are you, Mr. Briggs, whether or not portal tracks even when the defense lawyers log in to a certain file?
I don't know if it does that.
Okay.
Because
Go ahead.
I asked for our IT people in our office, run a search on this cause number and tell me who's accessed this case. And it only came back with employees from our office. So I didn't put a limitation on them. I said, just run me the search, and it was only people in the office. So I don't know if it's possible to see when the defense accesses the portal.
Prior to portal update, some evidence existed in CDs and DVDs, thumb drives. Is that correct?
Yes.
And you cannot track who accessed those or who opened those.
No, but those are kept under lock and key. Those are in a secure area in the office, and only people working on the Walmart case have access to them.
And in this case, there's quite a few people working on the Walmart case, correct?
Well, I don't know how you define quite a few, but there is Ms. Tarango, used to be Mr. Williams. We've had some attorneys that have come and gone over time that have worked on the case. But I think right now, that access is restricted to Mr. Hicks, Ms. Tarango, to Mr. Davis, and, well, I'm talking about who has access in the portal, our
Yes, sir.
lockdown portal.
Yes.
Mr. Hicks, Ms. Tarango, Mr. Davis, Ms. Stroud, the division chief over intake.
Lily
I
Stroud's
have-
in the appellate section?
She's in the appellate section. I have access, and then I think we also have the paralegals that are assigned to work on Walmart also have access, and I believe that is Ms. Chaparro. And,
Mr. Hernandez?
no, Mr. Hernandez is not working at Walmart anymore.
Okay.
As part of our efforts to wall her off from whatever she may have listened to. There may be one other paralegal, and then I believe the investigator that is assigned to the case. So,
So I'm going to ask you, I'm going to read out a list of attorneys and ask you if at one time or another they were on the case. Jaime Esparza, he was on the case.
I don't know that. I would assume he was the former DA. To be clear, I didn't have any involvement in Walmart until Ms. Rosales took office July 1 of 2021. So what was going on in the office under Mr. Esparza's administration on Walmart, I think I know who was working on it, but I wasn't involved, and so
Well, I'm going to ask you the ones that you're aware that the arraignment, it was Mr. Esparza who appeared with Ms. Tarango for the arraignment. Were you aware of that?
yes, because I've seen that
So at
footage
least-
on the news like 100 times, yeah.
Correct. So Mr. Esparza was on the case, correct?
He's the DA, yes.
Okay. James Montoya has indicated he's been on the case.
I don't know if that's true or not.
You've heard him talk about that in the past, have you not?
I don't know that I don't,
Okay.
actually, I don't think that he, I'm not trying to call him out, I don't know that he was.
Well, he
Because-
certainly indicated to the public that he was on it. He said he was there at the scene on day one.
That may be true. I know that at the end of Mr. Esparza's administration, we had the 3 active death penalty cases, and they had been divided up among the attorneys that were there that still had death penalty experience. And I could be wrong about this, but I thought that Mr. Montoya was working with Ms. Hughes on Facundo Chavez's capital murder case, and that the people that were on Walmart were Ms. Tarango and Ms. Butterworth and Ms. Enriquez.
Okay, so, okay. Well, certainly I think, have you heard representation from Mr. Montoya that he was on the case?
I've not.
Okay,
I've not
all
been
right.
following that.
All right. Mr. Arangos was on the case, correct? Is on the case?
From what I understood, yes.
Denise Butterworth was on the case?
Yes.
Ivan Rosales was on the case?
Yes.
You sat right next to her here in court more than once, Mr. Briggs.
Yes, unfortunately, I was present for that, yes.
Okay, all right. Curtis Cox was on the case?
Yes,
Okay. Scott Ferguson was on the case?
yes,
Charles Vance was on the case?
yes,
Loretta Hewitt was on the case?
yes,
Ada Nawari's on the case? And I may have not mispronounced her last name.
I know who you're speaking of, yes.
Okay. Mr. Hicks is on the case?
Her last name, I believe, is Waneri.
Waneri.
Waneri, yes.
Can you spell that, please?
No, I cannot. I will butcher it. It has a very
Right.
uncommon spelling.
You're on the case?
Yes,
Mike Williams was on the case?
yes,
Mr. Davis is on the case?
yes,
Okay. Haban Mohammed is on the case?
yes,
Lily Strauss, you mentioned, is on the case?
yes.
Kyle Myers was on the case before he went to the U.S. Attorney's Office?
Oh, I don't know about that.
You don't know? Okay. And then there's Monica Agger that was put on the case, hired by Ms. Rosales?
Right, I'm trying to remember what her last name was.
Auger?
Auger was like one of her last names.
Monica Auger.
But I know who you're talking about, yes,
She was on the case.
yes,
Rick Locke was on the case?
yes.
Okay. So there's been at least 19 prosecutors to date on the case, correct?
Sure, over 3 administrations, yes.
Amanda Enriquez, was she on the case?
I thought she was, yeah.
Okay. We have about 20 prosecutors that have been on the case at one point or another.
I wasn't counting, but I trust you can count to 20, so.
Mr. Briggs, are you aware that after Ms. Rosales resigned, how soon after she was resigned from office, did you come back to the district attorney's office?
She resigned on December the 14th, I think. Mr. Hicks was appointed that same day. I didn't come back to the office. I came back to the office on February the 21st of 2023. I remember it was the day after President's Day.
In all your experience as a prosecutor, do you believe that Ms. Rosales committed a criminal offense by her conduct in the Walmart case?
I'm waiting for some kind of objection by the state.
Go ahead.
I am going to go ahead and object. I don't know if that's proper for this hearing.
There's been a lot of expertise coming from the witness stand.
Yeah.
Overruled.
I am not familiar enough with federal criminal law to give an opinion as to whether or not there is criminal federal conduct.
How about state?
I've not, if I were to pick up the penal code and go digging, is there something that probably fits what happened? I'm going to say probably, but I also know that the state, on the state side of things, there was not a criminal investigation into her conduct or the conduct of those people between her and me in the office.
Right, and I was going to get to that in a second. The real first question was, I just wanted to know, based on everything you know, do you think she did anything wrong criminally?
Well, she did plenty that was wrong. Did it rise to the level of a crime? That would depend on what the investigation would turn up. There's what I know, and then there's what an investigation might turn up, and so we would have to see.
And the problem with that is that the district attorney's office did no investigation on Mr. Rosales. Is that true?
That was a conscious decision.
The answer is yes, they did not.
That was going to look like a political witch hunt, so no, the office did not conduct an investigation.
Go on, Mr. Spencer.
That's the same for Curtis Cox's actions and Roger Rodriguez. There was no investigation done by the district attorney's office as to all of their nefarious action that has come out publicly, correct?
That is a correct statement. When Mr. Hicks came in, he was inheriting a disaster, and I know the decision was made to move forward, rebuild, try and get the office back to functioning, and not to go look back and try and go after what may have happened, because that's a lose-lose. That's going to be seen as nothing but just a political kind of attack. And
So
Mr.
that
Hicks was
decision-
focused on going forward.
That decision was made for a political reason, because of the politics. So because of what the politics optics might be, we're not going to investigate the criminal action of Juan Rosales, Curtis Cox, and Roger Rodriguez.
This is just he's making this a political attack, not a
Let him finish,
discussion about the motions at hand.
let him finish his question, and then let me know what your objection is.
It was, I disagree with your characterization of it. It was an attempt to not appear that there was some kind of politically motivated investigation going on.
So if a citizen in Paso County commits a crime, if it can somehow be tied that it might be politically motivated, we're not going to investigate the crime?
Again, Your Honor, I reiterate my objection. He's continuing to make this a political statement as opposed to going to the heart of these motions.
Your non-legal objection is overruled.
My legal objection is relevance.
Overruled.
No, I don't think that's a correct statement. In this case, because of what was going on, the state did not conduct its investigation. Whether or not the federal government is or is not is where the federal government would have the ability to come in and investigate anything that happened, and they would be insulated from allegations that that was some kind of politically motivated investigation. So the state did not, and rightly or wrongly, I think it was left to the federal authorities to investigate the conduct of those individuals.
Would you have liked for the state to investigate Mr. Rosales and Mr. Cox and Mr. Rodriguez's action?
I don't think it's about what I like.
That's my question.
I'm indifferent. If an investigation was to be done, then so be it. And if not, then I would prefer that the federal authorities do an investigation and do something about it. Because I think that they had a greater ability to deal with the conduct of those individuals than the state.
I pass the witness, Your Honor.
Let's do this. I wanted to have them subject to recall. We've blown past our 15-minute break that we're getting closer to lunch. But let's, go ahead, Mr. Hicks. Let's wrap up Mr. Briggs. He's got other places to be.
Mr. Briggs, is the district attorney's office a prosecutorial or investigative entity?
We are primarily a prosecutorial entity.
What investigations does the district attorney's office engage in?
I can't think of any DA-driven, purely DA investigation cases that in my time in the office.
You've been with the office through 3 administrations, nearly 30 years as a prosecutor, including your time with the county attorney's office, and you can't think of a single time that the district attorney's office has driven an investigation.
That's correct.
A matter of investigation initiates with the law enforcement entities that are investigative entities.
Yes, typically someone, even when I know when complaints are brought directly to the DA's office, hey, I think that such and such is going on, that's illegal. I know that we refer those people to a law enforcement agency and say, you need to go make a complaint with a law enforcement agency that can conduct an investigation into what you're saying, and then at the end of their investigation, they may or may not submit a case to us for prosecution. But we don't do the investigation. We purely prosecute cases that are brought to us from investigative agencies.
So if, for example, there is an investigation going on out there, it would be incumbent upon us to maintain the integrity of that investigation by not speaking openly about it. Would you agree?
Yes, it's probably best not to be speaking about ongoing investigations.
regardless of the back and forth with Mr. Spencer regarding the logs, in this particular case, did you actually review any of the material in those logs?
No.
Any interest in reviewing the material in those logs?
In this case, no. I don't see how there's anything contained in the logs that makes a difference in how this case is going to play out at trial.
Regarding the hirings, job offers that Mr. Alhana made in that strange period after Ms. Rosales announced her resignation prior to my taking office, are you personally familiar with the fact that Mr. Alhana had been making job offers?
Yes.
And are you aware that there were numerous people who started in the office in January or late December that Mr. Alhana had made job offers to that I then allowed to go ahead and start in the office under my administration?
I'm aware that that happened.
And I would say your left arm is safe and secure. Thank you. I'll pass the witness.
Just a few, Your Honor.
Like last time?
Does the district attorney's office have investigators?
Yes.
How many do they have?
Ooh, probably a dozen or so, probably give or take. Let's call it a dozen.
Isn't it true that the district attorney's office also refers cases to PD to investigate?
No, I don't think that's correct.
Okay, well, let me ask you, Mr. Briggs. Certainly what evidence has come up, I'm talking about the Rosales fiasco, right, during her administration.
Okay.
There was a lot of evidence that came out in the hearings about death threats, witness tampering, perjury, attempted execution of a false affidavit. Those are all violations of the state penal code. Are they not?
I was mulling over the list that you just spit out there. I think the one that falls short is witness tampering. But what were the others?
The witness tampering. So when Roger Rodriguez is an agent for Ivan Rosales, goes over to the Hoffmans and tells them, you cannot come to the court, and I have snipers all around that's going to take you out if you don't do what I ask you to do. You don't think that's witness tampering?
Oh, well, look, witness tampering on the state side, it's not as easy as what you would think of as witness tampering, because the elements of witness tampering require that you're trying to get the witness to do something or not do something, but there has to be...
It is a state crime.
It is a state crime, but there has to be an offer of some kind of pecuniary gain. Either I'm going to pay you to go say a certain thing, or I'm going to pay you to not show up.
Or I'm going to
not
help
say
you get a
things.
U visa if you don't show up.
Right. So you have to promise them some kind of gain, or you have to do it by threat. So to the extent that if there's some proof of some gain or some threats, then I would say yes, that could meet the elements of witness tampering. But I think they're also, I haven't delved into the details of it, but I think if what you're referring to are the information that came out of the tape recordings of Mr. Rodriguez, I believe some of that also took place in Mexico. So I don't know. We would then have to get down and look at what happened in our jurisdiction, what happened outside of our jurisdiction, what promises, what threats, those kinds of things. It's possible.
Mr. Briggs, is this a fair statement? The DA's office, like every other DA's office, has an investigatory arm, and there is nothing in the law to forbid them from conducting an investigation that they can take to the grand jury, but the three administrations that you have worked with have decided not to do it. There's nothing forbidding them from doing it. It's just a policy in this county that has been followed maybe as far back as the Simmons administration. Is that a fair
Judge,
statement?
you were part of the Simmons administration, so you would know I'm going to say yes, that is a fair statement.
I think they did an investigation into the electric company. I think it was them that did it, but that It's a fair statement. They could, they choose not. There's nothing keeping them from doing it.
I think that's a correct statement.
Thank you.
May I approach the witness, Your Honor?
Yes, you.
Mr. Briggs, to be fair, I want to show you the appeal board, I want to ambush you, but I'd like to correct one of your statements you just testified to. With respect to tampering with the witness?
Thanks, I gotta find my glasses.
You want to use mine?
No, I don't want to. Here.
Just go ahead and read that part to yourself.
Okay. You specifically the underlines?
I'm sorry?
Specifically the underlined
Yes,
portions? Okay.
correct,
All
right. Would you agree that that falls into the category of a state crime that conceivably could have been attributed to Roger Rodriguez?
It's possible, yes.
Pass the witness, Your Honor.
We're not passing to anybody else, sir. Mr. Briggs, before they ask, you're still subject to recall, but you are free to go back to what you were doing before we brought you in this morning. Ladies and gentlemen, we're not even taking a 15-minute break. We're going to go ahead and go into our lunch period. I do need you guys back here by 12:45. We'll stand adjourned until that time.
All right.